think we're waiting for Ms. Winkles.
I believe Ms. Winkles is also on the attorney docket this morning.
Oh, for family law. Okay.
Yes.
And I was going to inform the court that that may take a little bit of time, so you might want to take other cases first.
Okay. And I see Alonza Teft present. Do we have any other parties on that matter?
Your Honor, Sherry Farr, guardian ad litem.
Okay. Good morning, Ms. Farr.
Good morning.
And Michael Teft.
Yeah, I'm here.
Okay. So let me just ask the parties. I'm not sure if Ms. Teft and Mr. Teft recall, but I am the commissioner who was initially hearing your protection order case. And so I don't view that as a conflict for me hearing this matter, but I certainly want to bring that up to the parties if either party believes that the information I learned through the protection order case in any way makes you feel like I can't be unbiased in this case. Please let me know. So I guess I'll start with you, Mr. Teft. Mr. Teft, do you have concerns about me being the commissioner in this matter?
Yeah, no, I don't have an issue.
Okay. And then Ms. Teft, do you have any concerns about me being the commissioner on this case today, given that I was initially involved in the protection order request, although the ultimate resolution of that was to let this guardianship case play out?
Nope.
Okay. So what I see, and obviously I was not the commissioner previously involved in this, but I do show back on May 19 that you folks were in front of Judge Michael Evans. I'm showing that as a non-jury trial. However, it doesn't appear that all parties were present. There was an order appointing an emergency minor guardian who is Ms. Teft. And then we set, the judge at that time set a review date for today at 10:30.
Your Honor, if I may give a little summary. So at that hearing, I'm not sure why it says all parties weren't present, because both parties were present.
Okay.
Both parties gave testimony and came to an agreement for the emergency guardianship to be put in place and supervised visitation to be put in place.
Got it. Thank you for that.
Since then, Mr. Teft was supposed to get a substance abuse evaluation. I know that he went to Core Health and initially signed up, but he hasn't gone back. They haven't been able to reach him. I haven't been able to reach him. So nothing further has done, no further drug testing, the evaluations. And I believe that's what the review hearing is for today, is to just see where we're at with that. I think that at this point, we need to get on the trial setting docket to get a trial set for the standard petition.
Ms. Teft, any additional information you have for our review hearing today?
Yeah, Michael hasn't made no effort whatsoever to even try to visit Annabelle or to try to schedule any visit whatsoever. Last time I checked, Michael, he's been drinking a lot. I've even sent the guardian item a picture of alcohol bottles in his car. It was like a bunch of beer bottles in there. He's been getting high and literally has not been doing anything to show that he's been trying to be a parent to Annabelle. He just doesn't seem to care or show any effort whatsoever. Just seems like he just wants to drink and go off and do other stuff and play the victim, the poor me card, and try to make people feel sympathy for him when he's the one who's not putting in the work or the effort to even try to be a parent to Annabelle.
Thank you. So, Mr. Teft, have you done the substance evaluation?
You're asking if I've taken the evaluation yet?
Yes.
I had, so the court and the guardian knows, and so everybody knows, I have not taken the test yet. I did do the packet. There was a financial aspect that I was actually bringing up today for the courts. That was the issue. I was down at the clerk's office, and there was actually a communicational issue when it came to receiving judge's orders. So I could take that down to meet the requirements of the mental health and the substance evaluation assessment or whatever. So I was actually going to request for there to be maybe another review, if the judge would be willing to accept that, so that I can actually get that done. After all, that is what the guardian, Sherry Farr, requested anyway. So I don't see there not to be no reason to get that done when that was a request already and a judge already had signed off on it.
So let me just understand what you're asking this court. So you're asking for a further review date.
Yes, a little more time.
But the kind of underlying question is, you haven't done the substance abuse evaluation yet. You do plan to do that. You just need more time.
Sure. Yeah. I'll have it actually. The paperwork in today. I was actually in the courthouse, picked that up, so that they finally have what they need, and then I can follow through with what they want to do.
Okay. And then have you done the parenting classes that the court ordered last time?
So I was doing step by step. So okay. I understand it takes a little time. And so as long as the courts are understanding of that, we can get all that done in due time.
Okay.
Your Honor, if I may.
Yes, please.
Michael, he wants to bring up this little financial thing. This was his decision to do visitation.
I'd like to interrupt for just a second. Ms. Taft, could you please ask the child to go into another room?
Sorry about that.
Can you just show us the room? Because I see you looking over at something.
She's not here right now.
Go ahead, Ms. Taft.
Sorry about that. She just likes to be around me a lot. But like I was saying, Michael, it was his decision to do supervised visits, to do all, to have to pay for a supervised visit, because originally I didn't want to do that because I knew financially he couldn't afford it. So for him to sit here and try to bring that up now, it's kind of irrelevant, because he was sitting here saying that he don't have money to do this, but yet he's going to the casino, he's drinking and buying all this alcohol, taking women out, and just wasting money, buying new car parts and stuff like that. It just doesn't make any sense for him to sit here and say how, oh, he can't afford something, but yet he's spending all this money on other stuff. And I can show proof and submit documents too of his income and what he's been spending money on as well.
So, yeah. So what it sounds like to me, the plan should be going forward, and Ms. Farr, please jump in after I go through my plan with any of your recommendations. I think, Ms. Farr, your first recommendation was that we do need to set a trial, get on the trial setting for the standard petition, which I agree with. Ms. Farr, if you are willing, I would like to reappoint you or have you remain as guardian ad litem for future proceedings on the standard petition.
I do have a order in place that was put in place after the emergency order was put in place.
Oh, good. Okay. So you're already appointed
yes.
on the standard petition. Okay.
One of the issues that I think Mr. Teff is having a hard time conveying to the court is in the emergency order, it does not specifically say that he needs to have a substance abuse evaluation or take the parenting classes. And because of that, he can't get that done at no cost. He can only get that done at no cost if there's a court order. So the clerk's minutes specifically say that Judge Evans ordered that, but the emergency order does not.
Yeah, I'm just pulling up Judge Evans' emergency order just to see that.
And Father did specifically agree. Actually, Father requested that the supervised visits be put in place. And he is the one that said he wanted it to be for 1 hour per week, and I gave him some choices of places that were lower cost. He decided that he wanted to go to a higher cost supervising professional, but he hasn't done that. So that particular financial issue is his decision. But as far as the evaluation goes, we just need to have that put in the extended order so that he can get that done at Core Health.
Okay. And it looks like, so I see on number 19 from Judge Evans, May 19th, 2023 order that he typed in, respondent father shall submit to a mental health evaluation and a substance use disorder evaluation and complete any recommended treatment. Respondent father is encouraged to complete additional parenting instruction / classes. Do you think that we need?
Oh, that's typed in, and that's why I didn't see it.
Well, I think, yeah, because a lot of things were written in, but then
Yeah.
that looks like standard language, but it does look like it was typed in.
Yeah, that should be sufficient.
So when we do the renewal order today, I will make sure to include that same language.
Also, Your Honor, real quick, if I may, Michael and me have contempt of court coming up. I've sent him a copy to his email, but I haven't served him a hard copy yet because it's been hard to try to track him down because no one knows where he's been at. He's been like ducking and dodging. But we have court on 1 second, let me get this correct. 1 sec. I don't want to make the wrong. 1 second. We have contempt of court on July 19th at 9:00. And honestly, Michael's looking at jail time because he's failed to follow court orders. And this is the third time.
Yeah. So ma'am, we'll address that at that hearing date. What I want to do is today, I will issue an order extending the emergency minor guardianship until we can get a final hearing on the minor guardianship petition. So let me just ask maybe Ms. Farr and the clerk for some feedback on, do we need to get them on the trial setting docket to get that minor guardianship trial date?
Yes, that's what I understand.
Okay. So what would be the next trial setting date that we could get these folks on? Next Wednesday.
Judge, can I just object to, that decision? Because I did state my reasons, and I am doing what's required.
Mr. Tuft, what are you objecting to?
To move to trial, because I'm still trying to, and going through the process of completing what is already required.
You can object. Your objection is noted. I'm still going to request that this be put on for trial setting. That is the process under the RCW, and we need to keep this moving forward. Certainly keep doing what you're doing, get the substance abuse evaluation, do the things that the judge has ordered. Just because you're moving to trial setting, all that means is on July 19th, you're going to log on to what's called universal trial assignment. At that time, you're going to get a trial date set into the future. Obviously, those trials don't happen the following week. So you are going to still have some time to get these things done. So what I need to do is keep this case moving forward, which is why I'm going to set you both to the July 19th universal trial setting, which is at 1 o'clock, 1 o'clock on July 19th.
Okay, that's the same day we have the contempt of court too.
What time do you have that?
Oh, that's at 9 a.m. So it's no problem.
Okay. Mr. Tuft, can you be available to log on for universal trial assignment on July 19th?
Can you hear me?
Yes.
Okay. Yeah, I wanted to actually object to that due to the contempt order as stated.
Yep, sir, we've already addressed that. I've noted your objection. I am still issuing my decision to extend the emergency minor guardianship through the date of the final hearing on the minor guardianship. I've set you for trial assignment July 19th at 1 o'clock. You'll log on to Zoom.
One more thing, Judge.
Hold on, let me finish. You'll log on to Zoom on July 19th at 1 o'clock. The link is called Universal Trial Assignment. Be prepared to let the judge know at that time how much time you expect for your case if you are objecting to the permanent guardianship. Ms. Farr, is there anything else that we need on this case today from the court?
Not from the court. I would just like to ask Mr. Tuft, are you still using the same phone number and email address?
Yes, the email is working fine.
The email is, but not the phone?
I'm in the process of getting a state phone due to finances.
Okay, can you find a way to contact me, please?
Yeah, I've been receiving your emails, so I'll just reach out to you.
And you need to check in with Core Health and get that evaluation scheduled right away.
Yeah, I was actually looking to just talk to Jill Karmy, the judge, and motion to dismiss, hopefully today, based on the contempt motion she's trying to bring to court. I mean, I don't know if that's something I take to the next court hearing, because it's her petition. It's clear that she's just
All right, so.
trying to take custody away from me.
It's court ordered.
Hold, Ms. Teft, both of you need to address the court, not each other. Ms. Farr, did you get contact information?
Yes, I understand what he's saying. I'm just asking him to contact me since his phone's not working.
Mr. Teft, please be in contact with the GAL, okay?
Is it an order?
I'm not sure I understand your question.
Is that an order to stay in contact?
Yes, it is.
Oh my God.
Okay. Next, I want to set a review date on the minor guardianship. So under the docket, we are currently on, separate and apart from next week's trial setting. I'm going to set a review date for Tuesday, September 19th at 10:30. And that will be a review date on this case.
Judge, is there still time for a motion to show cause? If I put one in?
You can file whatever motions you want the court to consider. We won't be addressing it today since it wasn't timely filed for today. But certainly we could address it on a future date, and you could note it on for any Tuesday minor guardianship docket.
All right.
Okay. Any questions from the parties at this time?
Nope, I'm good. I got the dates down. I emailed him the contempt stuff and I got everything down, so I'm good.
Okay.
Yeah, I have a question.
Yes, Mr. Teft.
Is there any way to appeal a judge's decisions on today's hearing?
You could file whatever motion you wish to file. Okay. All I've done today is extend the emergency minor guardianship, and I've had you all come back for a review date in 60 days. And I'm going to instruct you to appear on the trial assignment docket on July 19. But you are always welcome.
And then there's actually one more question too.
Okay, sir.
Yeah. Did you get the respondent's declaration on the minor guardianship? There's only one.
What date are you referring to? Originally before your non-jury trial?
Yes.
Yes, that is in the file. And then you had a non-jury trial where the ruling of Superior Court Judge Michael Evans was to grant the emergency minor guardianship. Okay.
Yeah. Would you be able to read that back just so that for the record?
Read what back?
The declaration that I had put in?
No, I'm not going to do that.
Thank you, because he's just trying to cause problems.
Establish a point is what I'm doing.
All right. So you have my decision. The record was made at the time of your non-jury trial on May 19. You are welcome to an audio recording of that non-jury trial transcript from the Superior Court Clerk's office at any time. So I'm going to finish this case. We're going to move on to the next case. Ms. Teft, Mr. Teft, you are free to log out. Do we have parties present on that matter?
I see one of the parties is present. Aaron Deere.
Yes. Yeah, it's I'm gonna be translating today, and my mom, Carolina Hernandez, is here, and the co-petitioner, Gerardo del Toro Soto. Oh,
So, okay, let me just, since I am new to this case, is this how we have proceeded with interpreters on this case? Because typically I would require a court certified interpreter for parties.
on the first court dates, bless you, baby. On the first court date that we had, we did ask for an interpreter, but I was kind of translating faster than the interpreter, so we just decided that I would translate. But if you would prefer a court translator, then we can, I don't know if it's too late now to do it, or if for the next one, I'll make sure to get a translator.
Well, the court will arrange that, but let me just make sure again, since I'm new to this case, who are the parties that you are translating for? Who is with you?
My mom, Carolina Hernandez, and my stepdad, Gerardo Soto del Toro.
And they are if I'm understanding the record correctly, and I heard you correctly, they are the petitioners in this case to be the guardians, correct?
Yes, yes.
Okay. So I do think it would be important that we have an interpreter, a court certified interpreter for them. Do we have any of the respondents on this matter present?
Not that we could see. We did inform them, but it doesn't seem like they're here today.
Okay.
And Your Honor, just so you know, neither parent has been served yet.
Ah, okay. Were there interpreters used in those cases?
There has only been one prior hearing that I'm aware of. And the daughter, she goes by Elle. She did do the interpreting, and in the interviews I've had with the petitioners, they do understand some English. They're just not fluent enough to communicate well. But she has been instrumental in helping with the interpreting.
Okay. And then, yeah, I just see from the hearing notes back from June 13, that is when the court extended the immediate emergency minor guardianship. But the permanent order needed to be served.
Correct. And they've put that into process.
Okay.
They have another relative in Aberdeen, which is where the parents are believed to be, that is going to serve. They've been provided, that person's been provided the documents. They're just waiting to get in touch with the parents.
Okay.
And one of the parents has been in touch with the petitioners just recently to get some visitation. So if that occurs, then the parents can be served that way as well.
My thought, and then Ms. Farr, certainly guide me if you have a different thought on this, but my thought would be to, because of the service issue on the petition and interpreter issue, I would probably extend the immediate emergency minor guardianship, set maybe just a 30-day review on this, on the emergency minor guardianship, where the court can have a court certified interpreter present.
Yes.
And then hopefully we can review for service on the regular petition at that time.
I think that would be appropriate.
Okay. So, ma'am, I know you are not a court certified interpreter, but what I'm going to have you do is just explain to the petitioners what I am doing today and giving a return to court date. Would you be able to help with that?
Yes.
Okay. Let me get a good date here. Ms. Farr, would August 15th.
So, excuse me. So the sole reason why you're rescheduling us is because I'm not a court certified interpreter?
No, there's two reasons. One is different judges and commissioners may do it differently. I do believe that we need a court certified interpreter. So that's one of my reasons. But my second reason is that I want to review whether the petition for the full minor guardianship has been served on the respondents.
Okay.
So two issues, and this is no jab against your interpreter skills at all. It's just when we have legal proceedings, we are required to have a court certified interpreter.
Okay. Me están diciendo que básicamente necesitan un intérprete de la corte y pues como yo no califico no van a poder seguir en la corte hoy y aparte necesitamos darle los papeles, servirle los papeles a Melissa y a Jaime. Como no hemos hecho eso, van a tener que hacer otra cita. So I did explain to them about the translator and not serving the papers, and he just expressed how it's been very frustrating trying to serve the papers to my brother and his partner because they're just always out. We really cannot contact them. They're the ones who contact us. They're always using random phone numbers. So it's been really hard to get a hold of them. Even the family member in Aberdeen has tried to get a hold of them, and my brother did contact to try to see if we could see the baby. He contacted me a couple of days ago, but other than that, like trying to get them the papers has been very hard because they're very hard to locate.
Otra cosa, el intérprete lo van a poner ellos o qué. Sí.
Yeah, yo puedo meter puedo pedirlo porque eso es lo que hice la última vez, pero no sabía que querían uno para esta cita también. Yo pensé que pues yo iba a estar bien.
And would you be willing to, well, let me ask first, Ms. Farr, would August 15th at 10:30 work for a review date on this, on the emergency minor guardianship?
Yes, Your Honor.
Okay. So ma'am, if you could let the petitioners know, they'll want to be back here in court on August 15th at 10:30 a.m. Same Zoom link that they logged in with today.
We also have another date for July 25th. And that was when we petitioned for full guardianship, not only the emergency one.
And we'll review at that time for whether service has been effectuated.
Okay.
So you want to, Your Honor, you do want to keep that July 25th date as well?
It's a great question.
Seems like they could be combined.
Yeah, why don't we, the only hesitation I have is since that is on the notice.
I also do want to say that I am going to be in Aberdeen because I live in Vancouver, but I will be in Aberdeen this weekend on Saturday and Sunday. I'm going to try to go and locate them so that I can personally serve the papers to them.
Okay.
So hopefully by the end of the day, Sunday, I will have them served.
Okay, I think that because July 25th is already on the paperwork for the full minor guardianship, let's just keep that date. Let's strike the August 15th that I was originally going to put you all on. And let's just have you reappear on July 25th, since that's on the documents that are going to be served on the party.
And the court will arrange for an interpreter for that day, or do I need to notify someone for that?
I'll send an email after docket to my judicial assistant to make sure we have someone for July
Okay.
25th.
Thank you.
And then I will issue an order extending the
La traductora. Ella la va a pedir la traductora.
anything else we need on this matter?
¿Van a extender la custodia de emergencia?
Is the emergency custody going to be extended?
Yes, it will.
Okay. What would the date be? Would that be July 25th when we meet?
Yeah, it'll extend through the next hearing date, and then we'll readdress further extensions at that time. In all likelihood, depending on service issues, we'll extend it through the date of the full hearing once the full petition has been served.
Okay. And would that updated emergency custody be given to us by Sherry? Or do we have to go to court?
I'll be filing it with the court after docket today. You can get a copy of it from the Cowlitz County Superior Court Clerk's office.
Okay, thank you.
And I'll give you a call sometime today and explain everything to you, okay?
Okay, thank you.
Thank you, Ms. Farr.
La custodia hasta el 25.
Okay.
¿Quieren decirle algo a la? No. Okay. They said thank you.
Oh, thank you. We will see you back on July 25th at 10:30. And I'm
Okay,
looking to
thank you
see
very
who I
much.
have present. Is that Teresa Maddox?
Yes, Judge.
Okay, good morning.
Morning.
And then do I have, oh, go ahead.
Amy Powers for the state of Washington. We just filed a notice of appearance and sent it over yesterday and mailed out our notice along with requests for child support to the parties. I doubt that anybody has received them yet, but I'm letting you know that we have entered a notice of appearance. The child is receiving TANF benefits.
Okay. Okay, and do we have any of the respondents on this case? Do we have Matthew Holt or Victoria Maddox? And do we have a court visitor or a GAL on this?
I was going to ask for a court visitor today, Judge,
I see that motion. So,
because we can't find Matthew. We have tried. Victoria has signed off. He has agreed to everything.
okay, so let me just get up to speed here because I had this is a somewhat unique case. So I just want to make sure I have all the facts straight. Ms. Maddox, you filed the petition to appoint minor guardian. Have you already gone through an emergency minor guardianship case, or is this the first filing?
This is the first filing. I was going to
Okay.
see if add that on today as well. I've had the child for a number of years now.
Okay. So that kind of brought up my next question and hesitancy, is I do see that you did file under the Indian Child Welfare Act notice, that you did provide notice to the director of, I guess, the alleged tribe of the child at this point, and the Portland regional director. So it seems like from your filings, you're very clear that the child is subject to tribal jurisdiction in some capacity. So what can you tell me about that?
Well, I had filed everyone's Indian roll number to begin with, so I've already gone through the process with the Choctaw Nation. Unfortunately, I couldn't get Naomi's because obviously I'm not legal for documentation. I talked to Michelle yesterday, which is the lady back in Oklahoma, regarding this matter.
Mhm.
She said that she received all my packet that I was required to send to her, but she wanted the additional information that I also had to serve to my daughter, Victoria Maddox.
Mhm.
So I scanned the documents and emailed them to her yesterday afternoon after our conversation. And I thought she was going to appear today from my understanding.
Well, that was my hope, because frankly, I don't believe, since this isn't an emergency guardianship filing, I don't think I have jurisdiction right now with the question mark of the tribal involvement. So I was hoping someone would be present, because I see that you did serve them with notice of today's hearing. So what I would be inclined to do at this point would be to set this matter out, to give them some additional time to respond to the court about whether they're declining jurisdiction or not.
Okay.
What's your thought on that?
I mean, if that's what needs to be done, I know I need to worry about the father, Matthew Holt.
Mhm.
My daughter, they were married at one point. I think that was in some of my findings. And when she had divorced him, she had got basically everything she'd asked for. He was required to do substance abuse counseling. He was supposed to provide drug testing and screening. He was mentally abusive. And he was supposed to have court-ordered visitation only with my ex-husband to see her, which he never followed through with any of it. Never seen my granddaughter, only has seen her once since she was 2. And which he should not have been allowed to see her. It was not in care at that time. So
Here's what I'm going to recommend is that we reset this matter. We continue this matter to August 15th, which will give the tribe 30 additional days to review and let us know their intentions. I'll see what the court can do on our end so that we can actually make some movement on the 15th. So that would be August 15th at 10:30 a.m. on this same docket.
Will I be able to get the court visitor to locate the father, or try to, while we're waiting for the tribe?
So I don't think that I have jurisdiction to appoint a court visitor until I know if this court can keep jurisdiction of the case.
Oh, okay.
So I'm not inclined to do that today. I think we need to address kind of need to go through the protocol for the Indian Child Welfare Act first, and then hopefully by August 15th, if they decline jurisdiction, or if we decide we are the entity with jurisdiction over the child instead, then we could move forward with appointments of a court visitor at that time.
Okay.
Okay. So this will get moved to August 15th at 10:30. I'll put somewhat of a burden on you to get back in touch with your contact with the tribe and let them know of the new hearing date and time. And then I'll have the court work on reaching out between now and then to them as well.
Okay, I will give her a call when we get off the phone or off the.
Okay. Okay.
Good morning, Your Honor. Mallory Smith, court visitor, present.
Good morning. I'm just looking to see. I do have an order for compensation. Did that get signed? It did already get signed by a judge. Okay. That was the most recent thing in my file. Our letters of guardianship expire 7/22, so it looks like we're still good there. The order extending the emergency guardianship will expire on July 22. So if we set this over just 1 week, that will be July 18. Are the parties comfortable with that?
That's good for me.
Okay.
That works for me as well, Your Honor.
Great. Thank you both. And I'm just going to assume no objection from Ms. Winkle. Oh, perfect. She said thank you. So we'll get that set over to next week, July 18th on the 10:30 docket.
Ms. Winkle.
Thank you, Judge. May I be excused?
You may, Mr.
Discovery. I
Gooday.
think
Thank
that
you
can
so
be
much.
set over. I mean, I've sent communication to her. We're working on her requests. My client's request for visitation, though, that needs to be heard sooner than later.
Okay. So her response was, okay, she said if we give her 5 minutes, she can hop on. She did say if we set over one, we should set over both. So would your preference be that we just wait the 5 minutes and see if she's ready to proceed at that time?
That would be my preference.
Okay, let's do that. We can stay on the record, but I'm just going to mute and turn off camera for now. So I see we have Ms. Farr present. Thanks for hanging in there with us. I see we have Kelly, and then is it Key Ludwig?
It's Kai, Your Honor.
Kai, thank you. We have Jaden Ludwig, respondent. Okay, I think that covers the parties present for this hearing. Thank you everyone for your patience. Sometimes when attorneys get scheduled for different dockets, we never know how long different dockets will go. So again, thank you for your patience. Let's first talk about the motion to compel. And if that sounds like the parties might be working together on that, but let me know if that's something you need the court to address today.
Yes, Your Honor. I've read Mr. Anagnostu's email to me and a supplemental discovery. I would just like a drop dead date. It's a very easy process. It just takes about 48 hours to download Google, and to download Facebook takes about 4 hours. I just asked that it be turned into me by no later than Monday at 4 p.m. It should be adequate time, and I'd ask for the entire file and nothing to be deleted. There is a little file that tells you if something's been deleted, but rather than have to come back in on a compel, I'd rather just have the entire file.
Concerned about that, Your Honor. If we could have it for July 24th. I have my IT guy working directly with Jaden, and we think we have the issue solved to get those downloaded. I don't know anything about it, so I'll try to get it to her by Monday, but for a drop dead date, if we could do the following Monday, just in case.
Ms. Winkles, and I'm just looking at trial. You guys will be on universal trial assignment tomorrow.
Correct.
Yeah.
It doesn't seem like the 24th would run afoul of preparations for kind of ultimate resolution of this case. Would the 24th be acceptable to you as the drop dead date?
Yes, because if there was an issue with the trial, I just asked that it be 30 days out. I have the trial books ready. That would be the only thing I'd be missing. So that's fine.
Okay. Okay. So what the court will do is then note that as far as this motion to compel is concerned, the respondent will have until July 24th at 4 p.m. to provide that discovery to Ms. Winkles.
And I just asked that that I'd be allowed to put into whatever order a full and complete discovery. We've had people in the past try to delete some of those files. So I just asked that full and complete. We're asking for essentially the Google takeout download and Facebook download.
And then the Facebook full and complete Google takeout and Facebook download. I can put that into a bench order.
Thank you, Your Honor.
Anything else?
Not on that, Your Honor.
Okay. So then, Mr. Anagnosto, it sounds like the remaining issue is your client's request to change overnight visitation. Does that sound correct?
Correct.
Okay, so I'll let you go ahead on that. I will let you know I have received the GAL report, the supplemental, GAL report, which does address that issue. I have the declaration of Kai Ludwig. I also have the respondent's bank statement showing hotel charges that you filed with the court. And I have the declaration of Jaden Ludwig. I have received and reviewed the declaration of Teresa Ludwig. Is there any, and that did also include picture attachments. Is there anything else that you believe the court should have for purposes of this hearing?
There was a declaration of Michelle Harrington.
Let me go back through my paper. I don't have it digitally, but let me just see if I have it in a hard copy. I reviewed these yesterday morning. So if it came in after that, I may not have reviewed it.
And I don't believe I've reviewed it either. What time did it come in so I can read it really quickly?
I could ask I'm not sitting at a computer that has my
Would it be Amanda that would have sent it?
Andrea, yeah, she would have sent it yesterday. I know we went over and filed it with a bench copy with the other documents. That was around noon. She would have sent it to you before then. So somewhere around noon or so.
Okay, I have reviewed that. Ms. Winkles, let me know when you have had a chance to look.
I'm ready.
That. Okay.
Yes, Your Honor. So, I'm going to start off by telling Your Honor that I'm going to make an argument to you that in 33 years of practice, I have never made this argument before, but I'm compelled in this case to make this argument that the petitioner's quest to obtain custody of Jaylyn, they have become evil. They're just doing downright evil actions in order to obtain custody of Jaylyn, and it's wrong. For example, in several declarations, the petitioners have referred to Ms. Harrington. They've referred to her age. In Kai's declaration that he filed here on page 5, you'll notice he mentions her age twice. It's my point, this is age discrimination. Somehow, Ms. Harrington's age is a factor for my client getting his daughter returned to him. And I'm, why is that? I mean, it would be similar if they were saying, if for example, my client had a relationship with somebody who was black, and they put that in every declaration. Well, so-and-so, and she's black. And well, here they say, well, Ms. Harrington, well, her age is 54 years old. And they do that every time. And it's wrong. This shows a bias, and I don't have any room in my life for bias to play a part in these cases. Now, the next thing they do is they, in their declaration, state that the child, that Jaylyn, has been around Michelle's son. And they base that on inappropriate hearsay of a child. Hearsay of a child is not admissible. It's not admissible. As you're aware, they've now put his picture in police reports and stuff. He is, a convicted sex offender in Oregon. They're trying to basically, this is my point. This is why this is evil. Jaden, if you go after custody of Jaylyn, we're going to try to have Michelle's son thrown in prison. We're going to do everything we can to have him thrown back in prison. How wrong is that? I mean, that's what that allegation is all about. Miss Farr jumps on the bandwagon. She says she interviewed the child. I don't know how she interviewed the child. I don't know if that was in person. I doubt it, because she's always professed to me that she doesn't do in-person contact with the child or the party. She hasn't seen my client with Jaylyn at all, never. So I'm not sure how she interviewed him. If it was over Zoom, were the petitioners there? Were they in the background? Had they prompted her before Miss Farr talked to her? And the point is, she said, I don't know, she had a number in her report 3 times or 5 times or some number that Jaylyn referred that she was at Michelle's house. And my client went, thank God, modern technology, your cell phone tells the world where you're at all times. So he went out and he got the pictures where they had taken pictures of her at the hotel room. This is one, he only gets over both a Saturday and Sunday, like every other weekend. And this was one of those times when he had a Saturday and Sunday, but he has to take her back at night. But anyway, his cell phone showed where they were at. They were at a motel room, and the pictures indicate that. So, you know, I don't know Ms. Farr's background in questioning a child, but it's easy. First of all, it's hearsay. It doesn't come in. I mean, but it's easy for me to comprehend that a 3-year-old child might think a motel room is Michelle's house, or at least she might be led into thinking that by adults who question her in an inappropriate manner. This is not a CJAC interview. It's totally inappropriate for them to come in and say that Jalen has been around Michelle's son, because that can now send him to prison. That's how bad that is. I mean, it's just pure evil for them to try to do that. And I'm just making this point to the court to know what lengths they're going to go to try to get custody of Jalen. And Your Honor's aware that we started trial on this in front of Commissioner Nelson, and it got continued, and then now we're going to have to start trial again. But they go on to claim that my client assaulted. They use the word assaulted Ms. Crape, and the guardian ad litem, Ms. Farr, has picked up that word. She has it in her report. My client committed an assault. It is absolutely not true. There was no assault. That's a criminal charge. If you want to bring a criminal record that where my client was convicted of some kind of assault, show us, bring it to court. They don't. They blink police reports, and it's interesting, very interesting, that they submit this is their declaration they submitted of Teresa Ludwig. In the declaration at the police report, Teresa Ludwig says, Caitlin grabbed she grabbed my client, Jaden, around his waist in a bear hug and put him on the ground. Kelly came up, grabbed his hair, and Taylor came around Kelly and kicked Jaden. And then her declaration goes on. So they submit a declaration where Kelly Crape had attacked my client. And that's what he's always said. She attacked me. Now, she went and she got a protection order, but protection orders have a very low bar. All you have to do is say in a protection order, I'm afraid of this person and I don't want them to be around me. Nevertheless, every declaration we hear my client committed assault is just not true. It's not true. And they're presenting arguments that are not supported by the evidence or the record. Now, it's important to note that when she got a restraining order, that at trial in front of Commissioner Nelson, Ms. Crape acknowledged that while the restraining order was in place, Jaden had no contact. My client had no contact. And if he had contact, she would have made sure that he went to jail. If he showed up to see his daughter, she would have made sure they went to jail. And so everybody agreed that while they believed the restraining order was in effect, my client didn't have any contact with his daughter. And the court rightfully was going to say, well, I'm going to discount that period of time because, showing up to see your daughter results in going to jail. That's a deterrent. And so Your Honor needs to be aware of that was all discussed. It was in the process of being tried, that very issue, yet they bring it up. They continue to bring it up that he went a long period of time without seeing his daughter and ignored the fact that there was a restraining order against him that had he done so, he would have went to jail. And then when he finally found out that the restraining order was lifted, he went to show up to pick up his daughter. They called the police. And that led to the beginning of this action. You'll see that all at the beginning of this action, based on that, they got a emergency ex parte order that Jalen stay with them. And here we are 10 months later, still trying to get to the trial on this issue. They're trying to take advantage of the fact that they had a restraining order against him, that if he showed up, he would, be arrested. That's an evil argument to the court. And they're hiding the fact when they say he didn't see Jalen for a period of time, that fact that they had that order. Next, Ms. Farr again brings up that my client signed a power of attorney. If Your Honor would look at that power of attorney, it clearly ended. It ended by the terms of that power of attorney on page 4, January 3, 2022. That's what it ended. Yet in every declaration, I continue to hear about this power of attorney. He signed the power of attorney. He signed the power of attorney. He signed the power. Okay, but it ended. So they were supposed to return Jalen to him when it ended. Well, the power of attorney has no effect. They agree it has no effect, but he signed it. Yeah, but it was self-ending. I mean, so they want you to focus on one part of it and not acknowledge and try to discount the other part of it, that it has ended, and my client is entitled to have his daughter returned to him. I had a conversation with Ms. Farr about that, because I actually had my client sign a formal revocation of that power of attorney. And she called me and said, well, he didn't have to sign a formal revocation. It ended automatically. Okay, Ms. Farr, then why do you bring it up every time we go to talk about it, about this power of attorney? So my client, was down and out. You can see the evidence. He was down and out and was struggling. He's young, 21 years old, and he signed a power of attorney for on a temporary basis while he got on his feet. He's on his feet now. He has a full-time job. He's has housing available at his grandmother's house, and we've supplied pictures of the residence where Jalen will be living. This is the house, coincidentally, that Kai Ludwig lived in with my client and his sister. But now, all of a sudden, that house is no longer, a place where Jalen should be. So, and then they have the wrong address, and they try to disparage Teresa Ludwig's house. And we've supplied pictures. We've supplied the pictures of the daybed where Jalen will be sleeping. She's, going to be very well cared for. Then there's a bunch of standard allegations. I guess I can't claim that these are evil, because you hear them in every case, Your Honor. He doesn't feed her right. He doesn't dress her right. She doesn't get naps. All those allegations are denied, and it doesn't prevent somebody from having custody of their child. And to prove that, my client has now started taking pictures of every visit, showing what she's dressed in, showing her taking a nap, showing him feeding her various meat, because we have to apparently document all this stuff, or else we're going to continue to hear their baseless allegations that he's not doing that, and it's just not true. It's concerning to me that the guardian ad litem has never seen my client with his daughter. Witnesses for my client, 5 minutes around him, they obviously recognize the close, loving bond that he has for Jalen and she has for her dad. But the guardian ad litem has never seen that, never seen my client with her. And lastly, the petitioners are now complaining about me. They've thrown in the fact that they don't want my client Jaden to have a court-appointed attorney. That is wrong on very, very many levels. That's not their issue. What they want is, because they have more economic power and they can afford to hire Miss Winkles, they want my client unrepresented so they can, kick the crap out of him in court and win this case. That's how bad they want custody of Jalen, and it's just wrong. It's just evil for them to challenge my appointment as court-appointed attorney, so that Jaden is represented in this action. My client makes a little bit above minimum wage. He's solved his housing issues. Jalen will be living with the grandmother, Teresa Ludwig. This is, as I indicated, a resident that where Kyla lived in the past with children. My client has looked into obtaining a daycare for Jalen. She'll be in daycare. She goes to daycare every day at the Ludwig's house. So they're not providing, the day-to-day care. So that's not a change. That's, that he'll find a pediatrician in Toledo, Oregon, where he'll be residing with her for Jalen. He needs custody of his daughters. So cut to the chase. This is what I believe is going to happen at trial. It will be shown that my client is willing and able. That's the standard under guardianship. to parent Jalen. Custody will be summarily granted to him, and the court will order a turnover in a very short period of time. Now, I have cites for 3 Calais County cases, Your Honor, that where the court has specifically summarily returned children to the parent. And I'm not sure if you want those cites or not, but it's several cases, and counsel and I have been involved on these, and the order is you will turn over the child tomorrow or in a couple of days, or it's never more than like a week. It's like this Friday, we're on a Tuesday docket, and they say you'll turn over the child this Friday. And when we go to trial, that's what's going to happen. That's what's going to happen, I believe. And again, if you want case cites of local cases, I can provide those. So my thought, this is just me, and this is the reason for this motion. We were working toward expanding visitation. Commissioner Nelson was doing that. We need to go to overnights and continue this process to work towards a smoother transition of Jalen into my client's household. That's the reason for this request. It's for her best interest, and so we want to increase the visits to overnights so that my client can do those parenting aspects of overnights. And they don't want that because they don't want proof to come into trial that he can put her to bed and get her up in the morning and feed her breakfast and dress her and all that kind of stuff. But when we go to trial and the court summarily returns her, that's exactly what's going to happen. It's going to be just a turnover right now. So our request is that we expand visitation while we're in this process of getting this to trial. I understand that we held off expanding it because we were in the middle of trial. We're going to finish trial, but now we're going to have to start over on trial. And so this needs to happen. The court needs to expand the visits because the petitioners don't see the handwriting on the wall. They're doing everything they can to avoid it. And they're going to lead us into a position where Jalen is summarily returned to my client.
Thank you. Ms. Winkles.
Yeah, there's a lot to unpack there. First off, I think it's necessary to kind of go through what the actual legal standard is here. So first, we have 2 legal standards, and the trial is actually not just the trial for the emergency. The trial is also for the minor guardianship. And the basis for minor guardianship is clear and convincing evidence that no parent of the minor is willing or able to exercise parenting functions as defined by RCW 2609-004. What those parenting functions are things such as making good choices for the child, having a place for the child to live, being able to personally provide for the economic necessities of the child. There's a lot of other things there. But I'm going to go and start in the same order Mr. Anagnostou does. The age difference. The age difference is not age bias. In fact, it's showing the reason that the age is there is because Jaden has a history of attaching himself to older women, including his grandmother and Michelle Harrington, nothing about her age there, about his age, and essentially mooching off of them. He doesn't provide for himself. He lives with them. He lets them do all of the parenting functions of his child. He essentially gets kicked out from one home to another, essentially using these women's economic status. That's why her age is mentioned. There is no bias here. The GAL is court appointed. Apparently, when she goes for Mr. Anagnostou's client, she's fine. When she goes against, she's semi-biased. The fact is this is a woman that has interviewed everybody in this case, has done more interviews on a lot of people in this case. My clients don't fully agree with her, and they believe that the thresholds should be even higher. But she has interviewed the child. And this is the thing. This child disclosed that she was taken to the home of a registered sex offender. Now, she didn't say that.
I object to child hearsay, Your Honor.
The GAL is allowed to report on anything told to her. And in her report, she clearly identifies having spoken to the child. It is not child hearsay.
Yeah, and my ruling will just be that I am going to allow it, and I'll obviously, I think that objection goes to the weight of the evidence, but not its admission. So go ahead, Ms. Winkles.
So we have Dad, who, I guess starting from the very beginning, this is a man who didn't bathe. You'll see in the declarations of Melody Boone, you'll see in the declarations, these are for CP 47 through 49. They talk about he didn't work. He pretended to work. He smoked marijuana. He had a domestic violence allegation in Lincoln County. He then has this assault where he was arrested. Mr. Anagnostou makes it sound like this was a man that was not arrested. This man was arrested for assault. When you hit somebody, it's an assault. Whether or not you're convicted is a different story. But we're not in criminal court right now. We're in court for minor guardianship. So he has a DV that's not even attached to this case in Lincoln County. He then is arrested for assault. You'll see the photos of my client's busted lip. The reason he was taken to the ground is because you'll read the statements, which Mr. Anagnostou fails to continue to read, that talk about how he was attacking my client. Teresa Ludwig, one of their witnesses, states that in her complaint, that they're in her declaration to the police, she was doing everything she could to get him off of her. Everybody was. The fact is, this man can't control himself. You'll see that in other court cases we've had where he essentially yelled at Dave Nelson out of the blue. This is a man who's never been able to keep a job. This is a man who got kicked out of Teresa Ludwig's house for failing to take care of his child. This is a man that a woman with no horse in the race, Melody Boone, says he essentially did nothing for his child, would leave his child in dirty diapers and would just smoke pot, play video games. He didn't even know where his child was at times. We then hear about him being kicked out of another house. What does he do? He drops the child off. Why this document that he signed is so important was because this is a man that decided he was going to drop his child off for a period of time with my client. So apparently these horrible, evil people are good enough for him to drop his daughter off with them and leave them. Now, this is important. They didn't have a duty to go drop the kid off after 6 months. This is the father. His duty is to go pick up his child. The fact is he didn't. He left the kid there and he never called. He never texted. And the reason this is so important is because the restraining order was between him and Kelly Craig, not between him and the child, not between him and his father. In fact, if you'll see by Kai Ludwig's declaration earlier on in this case, you'll see the text messages where he actually texts his son. And he said, please call me, please text me. They're essentially trying to get him to contact his child. He doesn't. He ghosts this child for over a year. It's not interested. He's not interested until his grandmother pushes him into it, tells him he needs to be a father and pushes him. And then suddenly he wants to be a dad again. He was always allowed at the house. There was no restraining order on the house. The restraining order was purely against Kelly Craig in person. She could have left. Kai Ludwig told him that. Did he do it? No, he had no interest in this child whatsoever. And I say that very specifically because I think it's really important to understand this was a child that dad didn't get vaccinations for. Fair enough. Some parents don't. This child was essentially deaf for a period of 18 months. She couldn't say one word because she couldn't hear. Did dad take her to the doctor ever? No. This child was so developmentally delayed that normal children are speaking almost full sentences at by this point. This child couldn't even say hello because she couldn't hear. He drops essentially a deaf child off that he has had no, what is he doing? What is he spending his money on? What is he spending his time on? He has no job. So why not take this child to the doctor? He doesn't. Instead, my clients take this child to the doctor, find out that she's deaf. She has surgery on her ear. She can finally hear. What do? They take her to the daycare where my client works and they work with her. They put her in a special program. Dad is of no help. They work with her every day. That child is meeting milestones now. Had that child been left in dad's care, that child would probably be incredibly developmentally delayed at this point, and there would probably be no hope of getting that child to a milestone. The fact is this child has only survived, been able to speak, been able to hear, been able to learn because of my clients, nothing to do with dad. The fact is that dad makes choices for dad. Dad makes choices for ease. Dad does what is easiest for dad to do. Where can he smoke weed? Where can he not work? Where can he sit on his rump and not do anything? And he picks older women to do that, be it his grandmother, be it Kelly Craig, be it his current girlfriend. The fact is we were already here on this in April, and Commissioner Nelson did not expand visitation. And the reason for that is because dad has done absolutely nothing to change his place. He took an online parenting course. That's it. Did he go to an in-person parenting course? No. He got a job. Fair enough. This is the longest job he's ever had. We don't have any information about this job, though. This is a man who once pretended he had a job and would leave and go smoke weed. So take it with a grain of salt. And that's the issue with him having a court-appointed attorney, is if he has a job now, why isn't he paying? Because my clients can't afford me. The fact is, you'll see a notice of withdrawal that was in their file before. They can't afford me. The fact is, we're not going to a trial again. They can't afford me. And yet, Mr. is the reason for this, leaving essentially developmentally delayed child. Yet he has a job. Why isn't he? He doesn't pay child support. He doesn't pay anything. So why is he not paying for his lawyer? At least child support or lawyer, one or the other. With the assault of my client, it's clear. It's really clear what he was arrested on. The fact is that none of the witnesses testified against him, being Teresa Ludwig, and so it was dropped. The DV in Lincoln City, I think, says it all, and we filed that with the court. There is testimony from a lot of different people that will confirm that my client was beat up. Again, the restraining order, that was only between Kelly. Why didn't dad care for a year? Why didn't dad try to do anything for a year? Why didn't dad come to see his child? He essentially left this child with these evil people doing nothing. Yet this child has flourished in their care. They don't want to keep this child from dad. They want dad to grow up, to get his own place, to keep his job, and to be able to take care of himself and the child. This is a man who didn't bathe for a month. This is a man who essentially moves from house to house, and here he's doing it again. He's now going to move back to a house that he was already kicked out when he had his daughter. He was already kicked out of grandma's house. This is a child that's going to be sleeping on a daybed in a living room. And this is a child that currently has a room. She's going to be sleeping on a daybed in a living room at grandma's house. Now, my question is, Dad has a job now that's 2 hours away from where grandma lives. We have asked Dad repeatedly, where do you live? Do you live with a sex offender or do you live with grandma? He refuses to state clearly. He always says, if I get the child, I'm going to move here. The fact is, we have no way of knowing that. This is a child that already disclosed she was being taken to a house where a man that raped a minor girl lives. Now, we're not trying to screw up this guy. We don't know him. We don't know him at all. My clients don't know Michelle Harrington's son. This is a civil matter. This has nothing to do with criminal charges. Even if this matter, they determined it was more likely than not that the child was around the sex offender, this has almost nothing to do with a criminal matter unless somebody takes it to the police, and it would have to be a reasonable doubt standard. The fact is we're on a different legal standard here. But this is what the child said. Now, has Dad done it every single time he's had visitation? No, which is why we were here on the discovery issue. The reason for Google Takeout is it does follow you. It follows you every single place you go. And the fact is that data is going to show that Dad absolutely drove that child to Michelle Harrington's house. It's going to show that he absolutely did. Even if you turn off your phone, it still follows you. And the fact is that it shows you, if you delete even one file from that program, it will show you. And the fact is they've done nothing and put no evidence in this court to prove otherwise. They put a few hotel receipts. Well, that's great. What about every other time? And if this man wants his child so much, I ask you, why is he always late picking her up? He comes an hour late, doesn't call. He drops her off early. He drops her off wet. He dropped her off this weekend with a massive sunburn, which we'll be presenting at trial. This is a man who always has somebody with him. Now, people have made statements that he's been with the child for an hour here, an hour there. That's not enough. The fact is he's going to do what he's always done here. He's going to delegate the authority and the parenting to an older woman. While this might be okay, the fact that Dad took that child to that sex offender's house and that Michelle Harrington's declaration didn't say anything about protecting the child. I think this is really important. The tone of Michelle Harrington's statement is all about protecting her son, the most important person, obviously, to her. This tells the court that she's not going to protect that child. The first thing she's going to do is protect that son. If that child goes there and gets molested, is anybody going to tell the truth? Most likely not. Michelle Harrington is going to protect her son, which is exactly what the tone of that statement is. How is Dad going to work 2 hours away from where his daughter lives and where he lives? The fact is he won't have a job again. He'll be right in the same place. The parenting functions in RCW 26.09004 clearly state that you have to provide for the financial support of the child. How's he going to do that if he doesn't have a job? It means that adequate education for the child, including remedial education, essential to the best interest of the child. Child was developmentally delayed, didn't say a word, Dad did nothing. Assist in maintaining appropriate interpersal relationships. Being around a registered sex offender that was convicted of rape of a child is not an appropriate interpersonal relationship. Attending to the daily needs of the child, such as feeding, clothing, physical care. Dad doesn't even bathe himself, and yet only took an online parenting course. Nothing has changed. If we look at the emergency order, it says a willingness and the ability to protect for the health, safety, and welfare of the child. This is a man who took a 3-year-old little girl to the house of a registered sex offender. He may have a willingness, but he definitely doesn't have the ability, because anybody with the ability to parent would make a decision not to take their child to the house of a registered sex offender. Anybody with a willingness to provide for the health and safety of a child would have a job that was less than 2 hours away from where the child lived. Anyone that would provide for the health, safety, and welfare of the child would not let a child be deaf for a period of 18 months while the child said absolutely no words, had no vaccines, and essentially never seen a doctor. This child is only possibly alive today, or at least thriving today, because of Kelly Craig and because of Kai Ludwig. Kai Ludwig loves his son, wants his son to become a man. Giving this child back to Kai Ludwig will be absolutely detrimental. It will be something that is irreparable. He can wait until trial to present his case and prove to the court that he's done some change, because the fact is right now he's a danger to that child. He's not just unfit, he's an actual danger. All it takes is for him to take that child once again to that house and for something absolutely horrific to happen to that child, or for him to fail to acknowledge another medical need and do nothing. And if we're relying on Michelle Harrington and Teresa Ludwig, that's inappropriate. They're not petitioners in this case. They're third parties that have no interest whatsoever. They're not the natural born parent. They're not married to Mr. Ludwig. He would essentially be delegating his parental authorities to another person who the court has not investigated, and that itself is not appropriate as well. I ask Your Honor to continue visitation as it is, to let this matter go to trial on the minor guardianship, to put forward the emergency guardianship. Procedurally, we've done it wrong. It should have been this type of hearing the whole time, a show cause hearing on the emergency, and then go to the minor at trial. That's why I put in a trial setting notice for the minor. The minor will be heard, will go on the trial setting docket on the 12th. At this point in time, the court doesn't have enough information from Mr. Ludwig himself to prove that he's safe. He's provided a few pictures showing the child eating fast food. He's provided nothing else but self-serving statements. There's nothing about his income. There's nothing about his ability to take care of himself. There's nothing about taking the child to the doctor. None of that. It's all from my client showing that they have taken over the responsibilities because Mr. Ludwig just doesn't have the ability at this time. Thank you.
Thank you. Mr. Ludwig, I see your hand. Mr. Anagnosto, do you want to talk to your client or advise him whether to speak during this hearing or not? I'll leave that to your discretion.
Yeah. Jaden, if you just listen at this point, and then we'll listen to Ms. Farr, and I think you and I can have a conversation in a breakout room and then come back, if that's permissible, Your Honor.
Yes, absolutely. Ms. Farr, go ahead. And I just want to be a little bit cognizant of time. The clerk and I both have docket at 1. We will have to take a break. So I have read your report. I value your input. I'm just trying to point out the time. So I'll turn it over to you at this point.
I'll try to be quick, Your Honor. Procedurally, this case is way off track and we need to get it back on track. Procedurally, the emergency order should have already been put in place. I filed my report in January. The emergency order should have been put in place then. The trial should be now being set for the standard petition. I was appointed in May as the GAL to continue on the standard petition, but I haven't been able to get into the crux of things because we still don't have an emergency order in place. That has to come first procedurally. So under 11-130-225, the court should enter the emergency order. Going forward, just to address some of the things that were said today, I have never made a reference about Miss Harrington's age. So there's no bias from me on that. I don't care how old she is. That isn't an issue for me. It is, the issue for me is whether the child is being properly cared for and protected and safe. I have never said anything derogatory about Miss Harrington's son. When I filed my supplemental report, I said that the child reported that she has been to Michelle's house. I made no mention of the child saying that she had been in or around contact with Miss Harrington's son. I don't have any information about that. I haven't finished interviewing the father about that. And I did say that in my report as well, that wasn't a completed investigation. As far as Mr. Anagnosto keeps bringing this up about me not interviewing in person. There's two issues here. First of all, my order that appoints me allows me to interview by Zoom. It says that I don't have to interview in person. I conduct all of my investigations this way. I've never had a problem with it. I recognize that there is a loving relationship between the child and her father. It is not necessary for me to see that in person. I'm not a supervising, I'm not a visitation supervisor. That part is not my job. I am well qualified in interviewing children. I've had extensive training. It is in my statement of qualifications. As far as the power of attorney goes, Mr. Anagnosto is correct. We had one conversation about that. It was through email. It was not a verbal conversation. So I don't know where that disparaging tone of voice comes when he's mimicking me. That doesn't make sense to me at all. And I've never brought that up except in my initial report when that power of attorney was signed. And it was revoked. And I do believe I acknowledged that. But the fact is, it shows that the father trusted the petitioners to leave the child in their care. That's what the signing of that power of attorney means. The goal is to return the child to the parent in all of these cases, when the parent can properly parent that child and it's safe for that child to be returned. At this point, we're still in a phase where there isn't an appropriate place for the child to live with the father. The father hasn't provided any proof that he is able to provide for that child and meet the statutory requirements to provide for that child. And nothing has really changed. All these hearings that we've had, and there's been multiple hearings, and at each one, the overnight visitations come up. Nothing changes from hearing to hearing. So there's no reason to expand those. His day visitations have been expanded. Nothing has changed with that. The same thing keeps occurring. As Ms. Winkles brought up, that pattern of being late, the pattern of not providing for the child, of, she was returned with a sunburn. I mean, all these things that he still isn't able to parent during the daytime. So the overnights are inappropriate at this point. And so just to bring it to a conclusion real quick, my position is that we need to get the emergency guardianship order put in place, get the trial set for the standard petition so that I can dive in and do my investigation on the standard petition. And, the other thing is that I don't know if this will do any good to bring up, but I would just like a little bit more professionalism in dealing with all of this, because all the derogatory and dramatic accusations, they're just fueling fire between the parties. It's not helping. So, it just would be good if we can just stay on the focus of what is best for this child instead of attacking each other.
Thank you. Mr. Anagnosto, did you want a breakout room with your client?
Just for a minute, Your Honor. I appreciate it. Thank you.
Miss Jaden Ludwig, do you have capabilities to enter a breakout room with your attorney? Okay. Mr. Anagnosto, how do you want to proceed?
Well, I want to proceed to a ruling on my motion. Just as a rebuttal argument, just a couple of points, Your Honor. Where we're at in this case is the petitioners filed an emergency guardianship. We requested an evidentiary hearing, which is allowed on emergency guardianship as opposed to just declarations. It's a very low bar, though, on the emergency guardianship. We were in the middle of the trial, the evidentiary hearing on the emergency guardianship. Ms. Winkles had put on a couple of witnesses and we ran out of time. And so we were in the process of resetting the emergency guardianship. We ended up here. We had it reset and then it got summarily stricken by the court when Commissioner Nelson retired. Commissioner Nelson started the trial. You heard testimony, and here we are. So it's my understanding that Ms. Winkles wants to try both the emergency and the main. I call it the main, the main guardianship action together. They do have different standards and they do have different elements, but she indicated to Commissioner Nelson that was permissible. We could do the trial on both of them at the same time. So I'm just responding to Ms. Farr's statement. The emergency guardianship is not before the court today. The only thing before the court is my motion to expand residential time. If we're going to do the emergency guardianship, I agree with Ms. Farr. We need an emergency guardianship order and a ruling on that. If we're going to do them together or if we're going to do them separate, that's up to Your Honor to decide. We need to get this moving along. In the interim, my client gets every weekend with his daughter. One weekend he gets a day visit. The other weekend he gets both a Saturday and Sunday. We want those to the Saturday, Sunday ones to be overnights. He has to come up here and generally spend the night anyway. And he should be allowed to feed his daughter dinner, get her up in the morning, bathe her, those type of things. And he's being prevented from that because, it's absolutely clear to me why, because they want to come into court when we do get to trial and say, well, look, he's never had an overnight, well, go figure. The court hasn't granted, and they're not going to grant it. They say they want this to move along, but the petitioners absolutely are doing everything in their power to not have this move along. And now they're attacking my client's son, which is still a concern. And counsel has brought that up in her argument again, as well, continuing to say that Jalen has been to Miss Harrington, thank you, Miss Harrington's home, which she has not. Inappropriate interview by the guardian ad litem of a 3-year-old child. I get to point that out. Miss Farr indicates that there's conflict, animosity in this report. Well, yeah, when you ignore the evidence that my client has provided, first of all, you don't talk to my client at all to begin with, and then you ignore his evidence of cell phone records and those type of things, saying this is absolutely not true, and you still promote that Jalen has been around Miss Harrington's son. That's just wrong on many levels. But so anyway, my response, Your Honor, is we need you to straighten this case out procedurally, and in the interim, while we get this going, my client on those alternate weekends should have his daughter. If you want to enter an order that says he cannot leave the state of Washington with Jalen, that's fine. He's not going to leave anyway. But we can put orders in effect, and he can start having overnights. But God forbid, the petitioners don't want that because they don't want that evidence presented at trial.
Thank you. Thank you to the parties for the written materials in reviewing and your oral argument today. I have reviewed the extensive history in this case, and let me start with the procedural issue, which I do see here. Here's what I see. Certainly parties jump in and correct me if I'm wrong, but initially there was an emergency minor guardianship put into place. There were a few extensions. The most recent one I can find is March 23 of 2023, and it looks like that ran through May 5th of 2023. And then there was supposed to be the start of the evidentiary hearing that ultimately had to be rescheduled. So I do think we need to either today or at a date very soon come back together to discuss or somehow address the lack of an emergency minor guardianship order in place. What are the parties' requests on that? I know, Ms. Winkles, you talked about a dual trial on that.
I didn't really. So
Okay.
that's the thing. It's not an evidentiary hearing. You don't get to request that. I'm not sure what statute Mr. Anagnostou is coming up with that. That's not the case. It's a show cause hearing. There's no testimony. If the parties are pro se, their testimony is in written statement only. You have to do a special motion before the court to request any in-person testimony. So I'm not sure where that came from. When I set this for trial setting, I set it for the minor guardianship. Dave Nelson put them together, but it's not appropriate. It should have been a show cause hearing. It's the immediate order is supposed to last 5 days. Then the emergency order is on a show cause. You don't have time to even do a motion to request testimony. So it's not a thing. There's no evidentiary hearing. It's all based on the pleadings. So it's supposed to be 60 days and then another 60 days and then possibly to trial on the minor. We didn't do that here, but that's what's supposed to occur. It's clearly laid out in the statute. There's only one case so far. But the timeframes tell you that it's not going to be an evidentiary hearing, or in the statute says that. It literally states it's a show cause based on the order, the mandatory forms themselves.
Do you anticipate noting this on for a show cause on the emergency, since it looks like there's not one in place, or what are the petitioners planning?
We can do that. I mean, essentially what we've done today is a show cause, but if there needs to be additional argument, I have no problem putting this on for a show cause hearing for next week, because it is supposed to be within a very short time frame for the emergency, and then the immediate is supposed to be within, it's the immediate, and then the hearing's supposed to happen in 5 days, which is frankly nearly impossible. But I can definitely note this on for next Tuesday.
Mr. Anagnostou, would you be available next Tuesday for us to address that procedural issue as far as whether or not the emergency minor guardianship can be put into place? And I frankly would be inclined to do it today, but I want to afford you that opportunity for additional time.
So this would be on the 10. I have one matter already on the 10:30 docket next Tuesday, so I'm here anyway.
Okay, that would be great. Let's go ahead and do that. I want the parties to know. Obviously, go ahead.
If I can just briefly respond, because It's my understanding those ex parte emergency orders are evidentiary, and there's a requirement that you put people under oath. I know there was a case I was involved in where people weren't put under oath, and it was overturned on a motion for revision. And basically, Commissioner Nelson required to make sure people were under oath during those hearings when they provided testimony, and that was an emergency.
So what we'll do, let's put this on for July 18 at 10:30 to essentially address the show cause for the emergency minor guardianship. Ms. Farr, are you available? Okay. And as the parties know, since I'm newer to this docket, Mr. Anagnosto, I will do research ASAP into the evidentiary component of that type of hearing.
Sure.
And I will email the parties this week with my understanding of what I would expect for that hearing so that we're all on the same page and you
Right.
can really prepare your clients.
Right.
So I will get that taken care of in the next 48 hours. I'll just, for the record, kind of go through, I understand procedurally how the visitation issue has worked through this case. I do see that the visitation issue has been addressed at several hearings. Additional evidence was presented for today. Most recently, I show on May 16 of 2023, that Commissioner Nelson held a hearing on expanding visitation. And he, at that time, issued a decision expanding daytime visitation beyond what it had previously been. But he declined specifically in that ruling to add overnight visitation. Based on the court notes from that hearing, my understanding is that he wanted to see additional steps taken by the respondent father before adding overnight visitation. He did not outline what those additional steps would or should be. But as I look back at the record and I hear the testimony today, I can, I guess, put myself in his shoes at the time of that hearing and kind of walk through what additional steps a judicial officer probably would want to see before adding overnight visitation. Clearly here, I don't view these petitioners as trying to keep the child from the respondent father. I think I have seen cases like these where the petitioners are requesting all sorts of restraining orders with the respondent parents and the child and asking for no visitation. And I don't see that here. I do see petitioners who are trying to balance the safety of a very young child who, I guess, given the age of the child, there's heightened concerns the court would have over, whether that child could properly report, whether there were any abuses of visitation or court orders. So I think that Commissioner Nelson was carefully crafting visitation to balance both the father's interests in being with his child, but also the need to protect the child given some of the issues that have come up in this case, and of course, pending a full trial. I understand that one of the additional steps the father has taken is to take an online parenting class. Kudos to him for that. I think that is a step in the right direction. It is not a step far enough for me, though, to change what the court has on numerous occasions indicated should be safe visitation standards in this case for now. So I am going to decline to add overnight visitation at this time based on the evidence in front of me and the record in front of me. I do think that the court has, throughout this case, struck an appropriate balance, again, with the father's interest in fathering his child, but also in protection of the child. In making this ruling, I also take into account that we have outstanding discovery issues regarding social media accounts and other technology issues that could, in fact, shed light one way or the other on overnight visitation and whether it is appropriate. And so out of an abundance of caution, I would be happy to revisit my ruling once discovery is fully shared, should that change or potentially change the outcome of my ruling in this case.
Your Honor, I have one question. My
Yes.
clients would like to have the transfers happen in a public place rather than at their house due to some of the allegations made. Can we make that happen? That we have it just, and for both parties' sake, considering what's been going back and forth.
And I'd like to point out, Your Honor, that they, at some hearing, demanded that my client go to their house. He didn't want to go.
Okay.
So we agree that we would like some neutral place.
Okay. Is there a proposal for where those what public place that should be, or do you just want to leave it as a public place?
We should probably have a definite, and then my clients can leave, I believe, whatever the court had before, so they don't have to wait. That is sometimes an hour late. So I'd ask that they only have to wait for 15 minutes. The pizza place is what my client states.
What's the name of the pizza? And what is that here in Longview?
It's in Castle Rock.
Castle Rock. Okay.
You have to go on mute.
Your Honor.
Yes, Mr. Ludwig. Yeah, we're running a little short on time here, so I need to ask you a very pointed question, which is, are you in agreement to make Papa Pete's in Castle Rock the transfer location?
I would prefer somewhere in Longview than Castle Rock, to be honest.
And the other thing is that it sounds like they want to change it such that if he's 15 minutes late, he doesn't get visits. That's an inappropriate change.
They shouldn't have to wait all day for him.
Yes.
And Your Honor, they do not wait on me all day at all. The reason sometimes I'm also late is because due to traffic. And yes, I do leave early enough, but still something could happen. Someone could get, lanes switched down to one lane and then I'm stuck in traffic.
I probably just right now, I mean, obviously.
They are waiting with a 3-year-old child in their car.
Yeah.
And that's why, Your Honor.
They're the ones who have set this up. So
okay,
that's why I have, that's why I suggest, that's why I feel like their place was fair enough. That way they didn't have to drive anywhere with the child and wait. But Your Honor, since they're wanting to now all of a sudden change it, I see that there shouldn't be a time limit, because if they want to change it, then that's their decision.
Thank you, Mr. Ludwig. Okay, here's what we're going to do. For now, I will issue a bench order that the child transfers will take place at Papa Pete's Pizza in Castle Rock. I'm not going to put a time limitation on it specifically in the order. I do note that with summer construction, especially in Cowlitz County, there could be delays that both parties may encounter. I know there's bridge work. I know that there's I-5 work. So I don't know how that's going to impact traffic. So for now, I'm going to leave it as is, but Mr. Ludwig, I just would caution you to be as timely as possible.
And I do try, Your Honor. It's just
Understood.
like I said, it's just everything going on.
I understand. So other than those,
Your Honor.
Hold on, we have to wrap up this.
I'm sorry.
I have 5 minutes to eat and get to my next docket, as do the clerks. So I think that
and me as well.
Yeah, and everyone else. I think we've taken all the testimony we need on this matter. We've made the rulings. We'll be here next Tuesday at 10:30. If there are additional issues that the parties need to address, please note those in your written materials, and I can be prepared to rule on them at that time. Okay.
Thank you, Your Honor.
Thank you. Anything else?
I don't know what time, Your Honor. I'm sorry.
For what?
For the meet time at Papa Pete's. The order says between 9 and 10.
Yeah, that's what.
Do you want me waiting there for an hour?
That is what's still in place. You've asked for it to change from your house.
Yeah.
That's what I can offer you.
Absolutely. So what I'm asking is, I need to be there at 9, correct?
Call me. I'll talk to you.
Yeah, perfect.
Okay. All right.
Thank you all.
Thank you, Your Honor.
All right, we're going to end the